Welcome to a Detroit courtroom showdown that's equal parts legal drama and philosophical debate. On one side, the city of Detroit, straightforward, procedural, and ready to move forward. On the other, Destiny Raven Graves, a defendant determined to challenge not just the charges, but the very foundation of the court's authority. Today, you'll witness a tense exchange about legal fictions, jurisdiction, and personal sovereignty that has the judge trying to keep the case on track while Destiny fights to redefine the rules of the game. Stick around because the back and forth you're about to hear is unlike anything you've seen in a typical arraignment.
This is the city of Detroit, Mr. Berry versus Destiny Graves, case number SB16, strike that, SB10699059, counts 1 and counts 2, SB172478881, SB1724805, counts 1, 2, and 3, and SB1724836-1. Appearance for the Mr. Berry.
Over that's Barry Jr. on behalf of the defendant. State your full name, Ms. Graves.
Good morning, Your Honor. I am Destiny Raven Graves. That's capital D, lowercase E-S-T-I-N-E-Y, hyphen, capital R, lowercase A-I-V-Y-N, colon, capital G, lowercase R-A-V-E-S. I am appearing specially and not generally. I am here in good faith and under the protest solely to address the matters raised in my plea abatement. I am not here to delay the process, but to ensure proper identification and lawful jurisdiction are established on the record before any further proceedings.
All right, good morning to you, ma'am. Today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or no?
I'm sorry, can you repeat that?
I said today is the date and time set for arraignment on the bench warrant. Would you like counsel to represent you or not?
I actually am not open to proceeding until we establish jurisdiction over the living woman. That's me, lowercase E-S-T-I-N-E-Y, hyphen, capital R, lowercase A-I-V-Y-N, colon, capital G, lowercase R-A-V-E-S.
Okay. Jurisdiction has been established if you are Destiny Graves. If you're Destiny Graves, if that's your name, then unless you have some other view of the court rule and you cite a court rule, the court is going to feel the jurisdiction has been established.
I understand, Your Honor, but respectfully, the name in all caps represents a corporate legal fiction. I am here as a living woman, not as a surety or a fictional entity. I respectfully require the court to establish, for the record, how to obtain lawful personal jurisdiction over me, the living woman, separate from that entity.
Well, I'm going to enter a not guilty plea on your behalf. I'm going to give you a $0 bond. I can either give you into the breakout room with the city with an attorney, and he can help you proceed, or you can proceed and speak to the city attorney yourself to see if you can work this matter out, or I can set a jury trial date and the matter will be resolved on the jury trial date. Which one would you like to do, ma'am?
Are you asking me if I would like to proceed for trial?
Yes.
I would respectfully, Your Honor, I would like to reserve all my rights under the UCC 1-308, and I object to these proceedings under protest and duress. My appearance is special and not general. I do not consent to the court assuming jurisdiction through presumption. If this court insists on moving forward without proving lawful authority over the living woman, I must note a violation of due process for the record.
Okay, so, I mean, if you can't give me an answer to my question, then I'm going to put you back in the waiting room until you can figure it out, and we'll move on to the next person.
What is your question, Your Honor?
I asked you, do you want to see if the attorney can get you an offer and speak with the attorney? Or would you like to work out an offer with the city yourself to resolve the matter? Or would you like me to set a jury trial date? Those are your three options. You keep on saying that same stuff is not going to change what your three options are, okay? So that's that. I don't need to hear that same recitation of what you just mentioned a minute ago. Now, what do you want to do?
So I'm sorry, respectfully, Your Honor, I do want to know, is this denying the abatement plea?
Say that again?
Is this denying my abatement plea?
I'm not getting into this, ma'am. I'm going to pass the matter. All right, let's go to, what is that? Huron Mendez.
Volvamos al caso del señor.
And there you have it, a case that turned into a philosophical standoff over jurisdiction. The judge held his ground, keeping the hearing focused on procedural options, while Destiny remained steadfast in her challenge to the court's authority. In the end, the matter was passed without resolution that day. It's a fascinating reminder that in court, legal arguments must meet procedural standards to gain traction. If you found this case as intriguing as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.